So first, I want to ask you if this is your signature on page 47. Is that your signature?
It could be, because if it's like by electronic, that's how I sign. Like,
Okay. And the question that I showed you, 12.1, let's say you want to read it or you want me to read it to you?
you could read it.
State the name, address, and telephone number of each individual who witnessed the incident. This is A, so paragraph A. Or the events occurring immediately before or after the incident.
Mm-hmm.
That's what the question is.
Yes.
As you sit here today, is it your testimony that Dr. Finke is a witness to the incident?
Absolutely.
He is a witness.
Yes. She knows. She was there.
Is Dr. Finke outside speaking with you?
Outside where?
On February 24th, 2018.
Outside like.
In the hall.
Yes.
He came out of his office?
Yes.
And your response in 12.1, this is what you responded with your attorney's assistance. So I won't hold you 100% at fault for it. But question, I withdraw. I apologize. The response is, responding party incorporates by reference the preliminary statement and general objections set forth above, subject to and without waiving the foregoing objections. Responding party responds as follows. Responding party may be contacted through defendant's counsel. Emani Ellis may be contacted through plaintiff's counsel. And then it says unknown staff / employees at Cedars-Sinai Medical Center, including at least 2 such persons who intervened during the incident. Discovery is continuing. Were you at Cedars-Sinai Hospital or Cedars-Sinai Medical Center when this incident occurred?
No.
Okay.
But to my knowledge, Dr. Finke works also for Cedars-Sinai, but we wasn't for Cedars-Sinai.
Is there any reason why your attorney or your prior attorney, yes or no?
We're not going to.
And at the time when you saw Dr. Finke, you knew his name at that time, correct?
I didn't know his name. And for a while, when I was getting asked by lawyers like his name and like the receptionist's name, I didn't know it because I saw him one time. So I kind of like just forgot about him.
But when your attorney asked you for the name for purposes of trial, then you did remember the name.
I didn't remember the name. I told him there was 2 witnesses, the receptionist and the doctor. I told him it was a doctor. My doctor came out at the time, the guy that checked me, and the receptionist. She knows. She was there. He was there.
Who knows?
The plaintiff. She knows.
How do you know she knows?
Because that's who separated. That's who separated and got in between us while we was verbally arguing.
Who got in between you?
The female receptionist, she came out first and she started like telling her, like, "You're security, what are you doing?" And then that's when the doctor came out. He was like, "Go to my office." And that's when I just walked away, and that was the last of it.
Okay. And 12.1 question. 12.1 subparagraph D. State the name, address, and telephone number of each individual who you or anyone acting on your behalf claim has knowledge of the incident. You just testified that Karan Newton was downstairs in the lobby on the date of the incident. You also testified that you told him different things about the incident. What is the reason, this is the question, what is the reason you did not disclose Karan Newton's name in discovery?
Because he wasn't upstairs.
And wait for the objection. It's a question.
First, this characterizes the testimony, it's compound, it's irrelevant to the merits of the case.
Sustained.
In written discovery, were you asked to provide the name of your security guard?
Your Honor,
Yeah, but why don't we? I don't know what you're trying to impeach her on because she hasn't testified to anything yet. You're saying it's impeachment, but you're not impeaching anything.
Did you respond to special interrogatory set 1 through your attorney?
Your Honor,
All right, the court's going to sustain its own 352 objection. Why don't you move on?
Do you consider Karan Newton to be a witness in this case?
No,
Sustained. Counsel, I need you to move on. This case isn't about discovery. You might want to move on to what it is about.
Is Tierra Malcolm a witness to this case?
Counsel, please.
Do you know who the witnesses are today?
All right, we're going to take a break, folks. Why don't we take a 10-minute break? We'll resume at 3:55. In the meantime, please do not discuss the case with anyone, including other jurors. Don't form any opinions or do any research. Counsel, let's define what we mean as impeachment. Impeachment is she says something, and you've got evidence that she said something else.
Right.
She said, I didn't know anybody's name. I got sent there. I was seen for a short amount of time. I didn't remember what their names were.
Okay, so
And now you're saying, here's this document that says you don't know what their names were.
okay, so maybe I'm
So-
going about it the wrong way. That's why.
You absolutely are, and you're not listening to the court's direction when I'm asking you to move on.
I'm sorry, I'm not doing it intentionally.
It seems like you are.
I really am not. I understand the court's issues, but I want to explain if I may.
Go ahead.
So I was going to ask her if she believes that Karan Newton is a witness in this.
He wasn't there. He was in the lobby.
Right, but 12.1 subsection D talks about witnesses that have knowledge about this case.
What knowledge does he have? He was in the lobby.
I was going to ask her. She spoke to him about it. That's what D is all
So,
about.
okay, so he was a hearsay witness, but she told him something.
Well, he's a witness.
Okay.
Also, in special.
So here's the other issue. You didn't depose her. If you wanted to ask these questions, you could have taken her deposition.
I understand the issue that if there is a special interrogatory number 15, which is on point, which asks a disclosure of the security guard. She
Okay.
didn't disclose his name, but she knows his name.
Okay.
So
So what are we going to do with that?
we're going to have the jury know that she didn't give the name of her security guard.
And what? So in order to be admissible, it has to be relevant. In order to be relevant, it has to be probative. Or so it's got to be more likely to show proof or disprove a material fact in the case. None of this has anything to do with any material fact.
Let me explain. Her testimony, Your Honor, is that Karan Newton doesn't know anything about this case.
She
However,
doesn't say that. She hasn't said that. She said he was in the lobby.
even better, plaintiff has testified that she has spoken with Karan Newton.
Okay.
It's in the medical records.
Okay.
He's a witness in some form or
So
fashion.
the appropriate means for you to do that is one, to file a motion to compel, or number two, seek evidentiary sanctions, which would have been handled pre-trial. But we're not going to have this witness testifying in trial in front of a jury about discovery issues.
That's fine. Right? The issue is, if it asked her to provide the name of the security guard and she didn't disclose it, why is it not fair? These are under penalty.
Then you file a motion to compel or a motion for evidentiary sanctions. You did need them.
She testified in her discovery that she was alone. Today, she testified she was with Karan. I want to ask her about that.
You already did.
I didn't show her the discovery, which is on point on that issue, Your Honor.
You're going to impeach her with the document saying that she was alone when she was alone in the elevator and the incident happened. That's your impeachment?
No. My impeachment is she did not reveal that she was with the security guard in the lobby, didn't do anything to provide his information when the other side,
Again, it's a discovery issue, so we're not going to go there.
so Your Honor, the other side was able to impeach plaintiff
With what?
with this discovery. They went into it at
When she
nauseam.
offered inconsistent statements in discovery.
That's what's happening here too.
No, she hasn't said anything inconsistent. She said she didn't know the person's name.
She knew
In
Karan.
discovery, she said she didn't know the person's name.
She knew Karan Newton's information. We asked for the name of the security guard.
All right.
She made it appear.
I'm going to ask you to move on. We're not going to get into further discovery issues.
May I just raise one point? I don't
Sure.
want the court to overlook. I want to point out this questioning started with a direct contemptuous violation of the order on the motion to eliminate, excluding any mention of gang affiliation, and that's the first question he asked.
Yeah, I don't expect that there's going to be anything further than that. I mean, you knew it was wrong when you said it.
No, I didn't.
You didn't know that there was a specific motion in the excluding.
The motion limiting, Your Honor, is prior to that act.
Nope. You might want to look at your trial binder to see specifically what it says. All right. All right. We'll resume in 5 minutes.